This is episode number 14 of the Inland Empire Workers' Compensation Lawyer live stream podcast. My name is attorney Alexander Napolin. I'm joined by attorney George Abuado, and today we will be discussing whether or not injured workers are required to have the diagnostic tests and medical procedures that are prescribed by their workers' compensation doctors. So if you're an injured worker and you've been told that you need a diagnostic test or a surgery or some other treatment, do you have to have it? And if you decline it, what does it mean for your workers' compensation claim? This is general information only. It's not legal advice. For legal advice, you need to dial our injury helpline at 844-984-8414 and request a free and confidential case evaluation.
A lot of people want to know, how is it going to affect my claim? And what are my options if I don't want to proceed with treatment, basically?
Right. Yeah, so there's a lot of different types of treatment you can receive under workers' comp, depending on the injury.
Correct.
And the question is do you have to proceed with that treatment if you don't want the treatment? And as you stated, you have control over your own body. You choose what treatments you have and what you don't have. But if you don't have them, you might not get better. And if you do have them, you probably will get better. So maybe you should have them.
Definitely. I always advise to, if it's a good doctor that you're seeing and there's objective findings, which are, as you know, x-rays, MRIs, things to show that you should definitely proceed with that treatment and it's reasonable and medically necessary, I say do it. When you have those types of situations where you don't want to proceed with surgery, I think that would be a great time, Alex, to talk about the two options that I usually give my clients when we're in that situation. Well, the first option is talking to your attorney about a possible settlement. Now, I want you to understand that we don't have all the information. The reason the panel qualified medical examiner, neutral doctor, is asking for these testings and for these further MRIs or x-rays or possible physical therapy, he's asking for extra things to happen is so that he can give the best assessment possible regarding your claim, regarding your injury, regarding apportionment, all these types of issues. So if he's not going to have those tools that he needs to complete his testing, he might not be able to do it. So at this point, the insurance company might look at this and say, okay, we don't have to pay for further testing. Maybe something worse is going to come out. Maybe the claims value is going to jump up. So they're willing to negotiate with you. At the same time, you have to understand that you don't know whether your claim might shoot up in value, or in the alternative, if all that testing is completed and there's nothing really there, your value could drop. It could go either way. So at this point, you have to talk to your attorney about what a reasonable settlement demand might be, and if you're comfortable with that. And if you're comfortable with completely closing out your claim without doing this further testing, without doing the recommended medical treatment. That's the first option I provide, Alex. The second way, without actually going through that treatment, is you can have your attorney write a letter to the doctor. He would also possibly discuss this with the defense attorney. It might even be a joint letter saying, my client does not wish to proceed with the recommended surgery, with the recommended diagnostic testing, x-ray, MRI, whatever might have you, etc. And they instead of going with that recommended treatment, they want you to put that in the future medical, and they want you to declare them MMI, permanent and stationary. I've had clients where they don't want to proceed with surgery. So the doctor says, okay, well, we recommend surgery. Since they don't want to have it right now, this is the point where they've reached maximum medical improvement because they're not proceeding with surgery, but that's still in your future medical. Now, if you do that, then now you have a final report where the doctor discusses everything, gives you a whole person impairment where you can get permanent disability, the number from. Now you have the permanent disability. You throw on that diagnostic testing, all that future medical onto your future medical in your final report. That adds value to your claim. So two ways: without getting a final report from the PQME, or getting a final report with the QME without actually having to go through with surgery or the diagnostics.
So there are ways to accelerate towards settlement.
Correct.
So if you're injured, you're going to have the option to pursue treatment or potentially settle your case. You might choose to pursue treatment if you know that you need that treatment, if you know that the MRI is going to reveal something significant, if you're having major issues, and if the qualified medical evaluator or your primary treating physician has requested testing or some type of procedure be done, you should go ahead and pursue that, or you might choose to settle your claim. You might choose to use that as an opportunity to negotiate with the insurance adjuster, because now the insurance adjuster is looking for having to pay out for an MRI or having to pay out some more med legal costs. That's money that they might be willing to shift over to you as the injured worker. Since you know more about your body than the insurance adjuster does, you'll have maybe an opportunity to negotiate with the insurance adjuster before diagnostic testing comes out that ultimately might reveal that your injury may not be surgical. So before the diagnostic testing is done, there might be exposure to surgery or more treatments, plus the cost of the MRI to the insurance company. It's a time when you can use an attorney to help negotiate a settlement. So if you don't have a lawyer and you're facing a QME and there's more diagnostic testing on the table and you're unsure about what to do, I think what George is saying is that it's time to call a lawyer and make sure that you talk through the specifics of your situation. That's why you need to call the injury helpline at 844-984-8414. That reaches the Inland Empire Workers' Compensation Lawyer live stream podcast injury helpline, where you can get legal advice about these issues. So the discussion for today is not legal advice. It's general information that's meant to help you, but it's not legal advice. For legal advice, you need to call and speak with a lawyer.
And I think that a really bad situation would be if you don't have an attorney and you reach this point with a qualified medical examiner and you don't know all these things. So you just tell the adjuster, I don't know if I want to move forward with surgery. You say, okay, no problem. You don't have to. Let's just be done with your claim. But they don't tell you all these things to put it in the future medical. They don't look out for you for your future, because that's going to be money out of their pocket. So they don't necessarily lie to you, but it might be information that you don't know, and that might hurt you in the future because you did not speak to a qualified, experienced attorney that's on your side.
You got to have a lawyer on your side if you're injured at work, because you can be taken advantage of by the insurance adjuster, whose sole goal is to, well, they're supposed to be helping you, but their goal is to save money on the claim, right?
Right.
I mean, if you stop asking for treatment, they're not going to just offer it to you. It's your burden to prove that you're injured and that you need care. It is the adjuster's burden to investigate if benefits are due and to pay them. But if you're not putting forth any evidence that more benefits are due, like you're not showing up to your diagnostic testing, or you're telling the adjuster, hey, I don't want to have the surgery right now, well, then you're either going back to work or you're effectively laid off from your job because you can no longer do it. You need to have a lawyer on your side to make sure that you're negotiating a better settlement or getting those procedures and diagnostic testing that you need, or making sure that it's provisioned in the future for you if you're not going to have it right now.
One last thing, Alex, I think that it ties in really well. What if your PTP, primary treating physician, a PTP is saying that you need surgery, but now you go to a PQME and they're saying, nah, I don't think they need surgery. But you want surgery and you feel like you need it, and your primary treating physician is saying, yes, you do need it. What do you do then?
We need to make sure that your primary treating physician has asked the insurance carrier for that surgery.
Right.
It's going to have to go through something called utilization review.
Right.
And if utilization review approves it, you're going to get it regardless of whether or not the QME thought you needed it.
Right.
I mean, that's what I would tell the client, is we got to push through with the primary treating physician.
Right. And that's the first step. PTP needs to send an RFA, request for authorization, to the insurance company. They will go through utilization review, UR, and see if you need it or not. Now, if you get denied, you can still do an IMR. But let's say that they're requesting the surgery and the PQME is saying no, and it gets denied because the PQME is saying no by utilization review and IMR. I think the next step that I would say is I would set up I would send the PTP report to the PQME, send an interrogatory to the qualified medical examiner. If that still didn't work, then we'd set up a cross-examination. But I just want to lay that out because I want our viewers and our listeners to know that this is so extremely difficult if you don't have someone on your side. Last time, this can get really hairy. It can get really convoluted if you don't know what the next steps are, if you don't have someone that's really experienced on your side and knows what to do next.
Absolutely. We're going to be covering a new topic every Sunday at 3 p.m. This topic for today is the QME, the Qualified Medical Evaluation and whether or not you have to get diagnostic testing and procedures that are recommended by the qualified medical evaluator or examiner, or your primary treating physician. If you're a worker in California, you should subscribe to our channel and hit the notification bell so you don't miss out on important discussions that will help you if you're injured at work. I encourage you to browse the station, find important discussions that will help you, but understand that this is general information that's meant to help you, but it's not legal advice. For legal advice, you need to call our injury helpline by dialing 844-984-8414 and requesting a free and confidential case evaluation.